Hello, guys. Welcome back. So, the part two of general meetings, the revision of part two of general meetings. Okay, I hope when you're watching this video, I hope you watched part one. And as always, the notes will be attached to the comment section down below. Okay, so without any further ado, let's get started. Okay, so in the last video, we stopped it at section 105. In this video, we will be starting from section 106. Okay, so easy way to remember section 106 to 110 deals with your voting rights, deals with your voting rights and types of voting. That's it. Very simple, very straightforward. One section for restriction on voting rights and four sections for types of voting. That's it. Nothing less, nothing more. Just remember, five sections are there. First section is 106, which is nothing but your restriction on voting rights. 107 is voting by show of hands. 108 is voting by, if you have studied, you will have to recall along with me. 108 is voting by electronic means. 109 is voting by poll and demand for a poll. And 110 is your postal ballot. Easy concepts. We will not just be looking at conceptually what are these. Of course, we will see what is the difference between voting by show of hands, electronic mean, postal ballot, poll, but also understanding the procedure of using these polls. Okay, chalo, let's start. Now, first thing, section 106, restriction on voting rights. The Articles of Association of a company may restrict a member's voting rights only in one specific situation, which, if there is any call or other sums which are payable by the member, and if they are unpaid. If the member was supposed to pay a certain amount, okay, sir, I'll tell you what is that certain amount. You would already know, but let's say there is a certain amount, okay. The member of the company was supposed to pay that certain money on a particular date. On that particular date, he did not pay that money. So automatically, company will automatically have the right to put restrictions on his voting rights. Okay. Or if the company has exercised right of lien. Now, first you quickly let's understand what is lien. Your charge is lien, your mortgage is lien, you understood hypothecation is lien. So what is happening in lien? Basically, lien is something where it is interest over something. If you have taken a loan from me and you have taken gold loan, okay. Now, let's say forget about gold loan. Okay, you have taken a loan from me and you have mortgaged your as a 30-40 land. Okay, 30-40 land, you have mortgaged it with me. Now, this particular land, I have a lien on it. That means if tomorrow you do not repay your money, if tomorrow you do not repay my money, then I can sell that land which you have mortgaged it with. That is lien. So when I sell your land, that is called exercising the right of lien. That is called exercising right of lien. So what do you need to understand quickly? First thing, there is a restriction on voting rights. One specific situation is when these sums which are supposed to be payable by the member, he has not paid it, then the company has the right to put restriction on his voting rights. And the second scenario is when the company has exercised its right of lien. Okay, in such case the articles of the association, so now to impose restrictions on voting rights, articles of association should be allowing you to impose restrictions on voting rights. Remember this can be a tricky question in your examination. What is that you need to remember? You need to remember that the restriction on voting rights will only be allowed if the articles of the company is allowed. Generally, all the articles of the companies, every company will have this provision. But if at all this provision is not there, then you will have to amend your articles of association and then put restrictions on your voting rights. The articles of the association of the company may deny the members voting rights in respect of those particular shares. Which particular shares? Those particular shares on which you were supposed to pay some money, on which you were supposed to pay some money and you did not pay it. Okay, only on those shares I will put a restriction on your voting rights. Let's say Mr. A has 100 shares. Okay, he has 100 shares. Out of these 100 shares, for 80 shares he has made full payment. and for 20 shares he is yet to make payment and he has defaulted in making the payment, so the voting rights on these 20 shares will be restricted, and there will be no restriction on the 80 shares. Even this can be a practical question. Now a question can come, should there be restriction on across all the 100 shares or only on those particular shares? How will you know that it is only on these 20 shares? By the wordings of particular. Okay, I hope this is clear. Let's quickly revise. Section 106 does what? Section 106 puts restriction on the voting rights of the on the members. On the members, why? Because of two scenarios. One, the members were supposed to pay call money. That is what I was trying to tell you. The call money. Okay, you have your first call, second call, allotment money for final call. All these monies are there. No, generally now this concept is not at all there, because all the shares now, even when you apply for IPO, you see someone paying in installments the share amount? No. Before they used to happen, they used to do it like that, but now no one follows that practice. Almost no one. At least I have not come across even a single company which is following first call, second call. No one is doing that. No application money, nothing. Directly full amount. But if at all some company still wants to follow this, they have the option. They still have the option to do this. And when they have chosen that option, if the shareholder is supposed to pay and he has not paid, then restriction on voting rights will come. Two conditions. One, articles of association should authorize you, and the restriction will be only on those particular shares on which you were supposed to make the payment. And the second scenario is the company has exercised right of fee. That's it. That is section 109. Okay, and there can be no other ground for this restriction. And 107 is voting by show of hands. As the name suggests, you are voting by raising your hand, saying that, sir, I am voting against the resolution or for the resolution, nothing else. Okay, that's it. Observe one thing. Observe one thing. In voting by show of hands in section 107, in 107, repeat it with me. Okay, repeat it with me. In section 107, voting by show of hands, everyone around you will get to know what was the vote that you casted. Everyone around you will understand what was the vote you casted. Did you cast the vote against the resolution or for the resolution? That is the difference between all the other types of resolution. Only in show of hands you get to know who voted for which resolution. And that is the reason, see, I might be a person, I want to vote against the resolution, but I am scared to tell the company that I am voting against the resolution. So now I'll go to section 109. I'll say that, sir, I want to demand a poll. In poll, it is just like your legislative elections will be happening. No, you will be electing your state elections or central elections where you go and press the button in the polling booth. That is poll, where you do not get to know who is voting for which party. Similarly, even here, once I opt for poll, that is my right. Okay, there are certain conditions for demanding. Let us see this. Let us see that in this revision. Okay, just remember this. Okay, I hope you're going to remember this. You can demand for poll with certain conditions. So only by voting by show of hands, people around you will get to know what was the vote you cast. That is the reason to see. And so just a quick detour from the concept shareholders democracy. What is shareholders democracy? Simple words, shareholders should be involved in the management of the company. Shareholders should be involved in the management of the company. How will shareholders get involved in the management of the company? The best way and the only way is casting their votes. If they are hesitant to cast their votes, then what is the point of shareholders democracy? That is the reason they have given also the shareholders an option to go for poll, whereby I am free to cast a vote whatever the hell I want. I don't have to wait for anyone. I don't have to worry that if that person is seeing, this person is seeing, that director is seeing, this auditor is seeing, nothing. I can cast vote of whatever I want. Okay, that is why you have poll, postal ballot, and electronic. Understood the difference? Now coming to section 108, voting by electronic means. Now tell me one thing. There are important agenda items, 108 and 110. Let's understand it conceptually together. Now, the company that I invested is in Jammu and Kashmir, but I am staying in Kanyakumari. Now I want to cast my vote. And even Companies Act is telling that this is a very important decision. And Companies Act is telling the company, if at all you are taking a decision on this particular matter, what should you do? You should, you should, you should make sure that this resolution is voted upon by postal ballot. Why? Because it is not practical for people like me who are staying far away from the company. Why? Because the place of general meeting is generally the registered office of the company, or the place of the or where the registered office is situated. Now it is not possible for me to travel all the way to Jammu and Kashmir to cast my vote. So what will I tell? You do one thing. You have sent me the notice. No, I've received the notice. I know what is the agenda item. So what will I do? I will cast my vote in Kanyakumari and I'll post it to you. I'll do speed post if you want. It's the same concept, no? It's the same concept. Even here, anonymity is there. But here, the added advantage is I don't have to attend the general meeting physically. And the same thing happens with electronic means. So, this is a matter of convenience. See, and again, going back to your shareholders' democracy. Your democracy, I will say that your company is democratic when more and more shareholders are participating in your company's management. If less number of members are participating in your company's management, I would assume that your company is not that democratic. Now, there are certain decisions where the company law, where the Companies Act 2013 itself requires the company to take votes by postal ballot or e-voting. Reason being is simple. I want more and more people. I want to make sure that all the members are casting their vote on this particular resolution. So for this reason, more number of shareholders will be able to vote only through electronic means and postal ballot. And poll, of course, you have to go to the general meeting to cast your vote. Voting by show of hands, you cannot sit at home and show your hands. You have to go to the general meeting and then show your hands. This is the five sections of voting rights. Okay, first one is restriction on voting rights. Okay, quick revision. What are the two scenarios? When there are any unpaid dues which were supposed to be paid, then the company can restrict on your voting rights only on those particular shares. Okay, only on those particular shares. Second, or when the company has exercised the relief. These are the two scenarios when the company can put restrictions on your voting rights. But here the main condition is what? Articles of association should authorize you to allow you to put this restriction. Second, 107 is voting by show of hands, 108 is electronic means, 109 is poll, and 110 is postal ballot. So these are your five sections. Now let's quickly go through the procedure. Okay. So now let's look at e-voting. E-voting allows the members to cast their votes on resolution without physically attending the general meeting. It was introduced to enhance the participation of the minority shareholders. Because generally, people who attend the general meeting, we think that it is, and it is true also to a great extent, that generally people who are attending the general meetings, they are majority shareholders. And minority shareholders, it is not. Now I am holding 2000 rupees share. Let's say I'm holding 2000 rupees share. Now tell me one thing. To exercise my voting right on this 2000 rupees of shares, I have to go to Jammu and Kashmir. Flight tickets will be nothing less than 8 to 10,000. So to and fro would be 20,000. Do you think I would spend that? Even if I'm going by train, even if I'm going by bus, or no matter how I'm going, I'll end up spending way more. Practically, think practically. Do not think, do not try to memorize it. Okay? Because of now, even minority shareholders will be able to cast their votes from the remote areas. Importantly, e-voting does not eliminate a member's right to physically attend. Now, just because you have casted your vote online, no one can stop you from attending the physical meeting at the registered office. Now, tomorrow, I casted my vote electronically. I cannot go now when I go and attend the general meeting. The company cannot stop me from at- cannot stop me from physically attending the general meeting. That is the difference. Okay. Then who must provide e-voting? Two companies, listed company with over 1,000 shareholders or more, and companies with paid up share capital of 20 crore or more on the last date of the preceding financial year. Simple. Okay. Then exemption, Nidhi companies, SMA exchange, companies listed on SMA exchange or institutional trading platform, companies whose only debentures or preference shares are listed. So if so now you need to have a quick understanding of security laws. there are four types of stock exchange: main board, small and medium enterprises, social stock exchange, and innovators growth platform. Just remember for this, okay, SME exchange is already covered here. Whether equity shares are listed on SME exchange, or preference shares are listed on SME exchange, or debentures are listed on SME exchange, does not matter. As any company whose shares are listed on SME exchange, whether equity or preference, they need not provide e-voting facility. Then the second thing, come now, of the companies who are listed on main board, that is your National Stock Exchange and Bombay Stock Exchange. Here, only those companies. Which companies? Only those companies who have issued equity shares, only they can, only they have to provide e-voting facility. And any company who has listed their shares either on NSE or BSE, that is basically the main board, if they have listed preference shares or debentures, they may or may not provide e-voting facility. Understand the difference between SME exchange. SME exchange, it does not matter whether equity share, preference shares, or debentures. You have the option, you may or may not provide e-voting facility. But if you're listed on main board and you have issued equity shares, then you will have to provide e-voting facility. Whereas in preference shares and debentures, that is not mandatory. Okay. So exemptions of e-voting is clear. Now, let's look at the procedure of e-voting. There are totally six steps. Okay. First thing, board actions. What should you do? Appoint scrutinizers, appoint an agency, fix the cutoff date. What is this cutoff date? Cutoff date is the date of the list of the shareholders someday. Because every day the number of shareholders will be changing. No, today I am purchasing 100 shares. Tomorrow I'll sell all these 100 shares. So the shareholding structure of the company will keep changing. So it is very difficult to, if I do not put a cutoff date, then it would be very difficult to ascertain the votes. So, in simple words, whoever is shareholder on that cutoff date will have the right to vote. As simple as that. Clear? Then, notice requirements. Notice must be sent by registered post, speed post, courier, or email. It must be placed on the company's website. Notice must clearly state the following information. Then, public advertisement. The company must publish a public notice or advertisement at least 21 days before the date of general meeting. At least 21 days before the date of general meeting. Okay, so let's quickly revise. Section 106 was restriction on voting rights. Section 107 was voting by show of hands. 108 is electronic means. What was the difference? Voting by show of hands is the only mode of voting where other shareholders and everyone attending the general meeting, basically everyone around you, will be aware of what was the vote that you casted. But whereas in e-voting, poll, and postal ballot, there is anonymity. And the difference between e-voting and postal ballot, sorry, the difference between e-voting and poll is what? Sorry. So what was the difference between postal ballot and poll? Postal ballot, you will have to physically attend the general meeting, whereas in e-voting and postal ballot, it is not mandatory for you to attend the general meeting physically. Okay. Then moving to step 5, simple: members present at the meeting who have not exercised their right through remote e-voting shall be allowed to vote through ballot paper, polling paper on the same electronic system used for remote e-voting. Then declaration of results will happen. But here, what is important? Two witnesses, not in the employment of the company. Okay, there can be a question even just based on this provision. Okay, then demand for poll is your section 109. A poll is a method of voting where the votes are counted based on the number of shares held by each member rather than one vote per person. A poll may be demanded before or on the declaration of the result of voting on show of hands. Okay. So now coming to the conditions of when can you demand for a poll? Of course, if there are 100 shareholders, one single shareholder is going and telling I want. It does not work that way. Okay, you need minimum threshold. So what are the thresholds? Now again there are two categories: company with share capital and company without share capital. Of course, okay. Now where company is having share capital, at least 1/10 of the total voting power or holding shares of aggregate paid up value of at least 5 lakh rupees. if your paid up value, if you are someone or together with someone, combined paid up value is at least 5 lakh rupees, then you will be entitled to demand for a pool. Okay, or 1/10 of the total voting power. Then, company without shareholders. Any member having at least 1/10 of the total voting power. Here, paid up value does not come because the company does not have share capital. And when you are looking at paid up value, you will only and only look at face value, and market value is immaterial. Market value is immaterial. Okay. And then, what is the time for taking the poll? Poll on adjournment of meetings or election of chairman shall be taken forthwith, that is immediately. Poll on any other question shall be taken at such time not later than 48 hours from the time of demand. Okay, the demand for poll may be withdrawn at any point of time. You would have demanded right now, but you can also withdraw it. The result of the poll shall be deemed to be the decision of the meeting. It shall be deemed to be the decision of the meeting. Then the scrutinizer's role, he has to prepare the polling papers in MGT 12 and MGT 12. MGT 13 is the report that scrutinizers submit to the company. Okay, MGT 12 and MGT 13. Then postal ballot is section 110, voting by post or through electronic mail. End of the day, even if you are sending it through registered post or you're voting electronically, the concept is the same. That is the reason when you read section 110, the language reads as means voting by post or through electronic mode. And understand what kind of definition is this? It is an exclusive definition. So only these are the only two modes which will be covered under section 110. Either you should be sending a post or it should be through electronic mode. It is a mechanism through which the shareholders exercise their votes on the resolution without attending the general meeting, whatever we have discussed till now. Okay. Then you have the procedure, which is similar. Even here you have the scrutinizer. Because see, what is the role of scrutinizer? The role of scrutinizer is simple. I am calling the scrutinizer to ensure that the votes that are being counted, it is counted in a very rightful manner and that there is no mismanagement happening while I'm counting the votes. Okay. Okay. Then coming to, then you have circulation of resolution. Okay. Then coming to section 117, which are the resolutions that needs to be filed with the registrar. You would, whenever you would have studied across resolutions to be filed. Okay, so now which resolutions? So you remember across wherever you were studying company law, you would have come across those topics where they would ask you to file, where the Companies Act requires the company to file MGT 14. That is under section 117. Why? There are certain specific resolutions which you are passing at the general meeting, which needs to mandatorily be filed by the company with the ROC. In which form? MGT 14. Within how many days? Within 30 days. Within 30 days from what date? From the date of resolution. Quickly remember MGT 14, timeline 30 days. 30 days commences from the date of passing of the resolution. First thing, every single special resolution that you pass in a general meeting needs to be filed in MGT 14. Resolutions agreed to by all the members of the company, but which, if not so agreed, would have been required by special resolution. So, generally, all the members of the company agreed to that particular resolution. Even if they did not agree, it would have triggered the requirement of special resolution. Then, any board resolution or agreement relating to appointment or reappointment or renewal or variation of terms of appointment of the managing director. Resolutions agreed to by any class of members, but which would otherwise have required a specific, which would have otherwise required a specified majority. Resolutions on voluntary winding up and resolution passed under section 179(3). What does section 179(3) deal with? Powers of the director. Okay, section 179(3). The list of the powers in given under 179 subsection 3, all the powers are listed of the board of directors. Regarding those, under those circumstances, wherever you require the shareholders approval, in those cases, In those cases, you will have to file the resolution with the ROC. Okay, remember these 6 points. Then penalties is simple, 10,000, 100 per day. Then whoever is in default, 10,000 rupees, and officer in default, whoever is continuing default, then it's 100 per day, 10,000 and 100. Simple and not so important also. Then maintenance of minutes of the meetings. Section 108 applies to both general meetings as well as board meetings. Okay, even the board meeting minutes have to be maintained as per section 118. Even your general meeting minutes have to be maintained as per section 118. All the general meetings of the members, all the meetings of any class of shareholders, all the meetings of the board of directors and the committees of the board, all the resolutions passed by the postal ballot. The minutes shall be prepared within how many days? 30 days. 30 days for MGT 14 and 30 days for the minutes preparation. Okay. Then rules for maintenance of minutes. Which minutes? General meetings, meetings of creditors, meetings of the board, meetings of the committees. Okay. Meetings of the creditors. And this is where your committee of creditors is also important. Under insolvency and bankruptcy code, when a company becomes insolvent, it is not the shareholders who are in control of the company, but the creditors who are in control of the company. That is the reason most of the times when the company is gone insolvent, you will not see general meetings, but what will you see? You will see meeting of committee of creditors. Even those meetings have to be maintained, even though minutes of those meetings have to be maintained as per section 118. Okay. Then signing of minutes. Each page shall be initialed or signed. Okay. Then last page of the record signed and dated by the chairman of the same meeting within 30 days of the conclusion of the meeting, or in the event of the death of the chairman, then the director who is duly authorized by the board of directors to sign, to make the signature. Then preservation, it shall be preserved permanently. See, most of the books and registers under Companies Act are to be maintained for 8 years. Okay, that is the general rule. But here they have specifically told that they have to be maintained permanently, and these minutes will be under the custody of the company secretary of the company. Okay, the minute books of the board and the committee meeting must also be preserved permanently at the registered office or any other place approved by the board. Scheme of merger and amalgamation minutes books or the transferred company handed over to the transferee company must be preserved permanently. Okay. Then penalty for default is 25,000 or 5,000. Then special category section 8 company and specified IFSC public or private companies. Then section 121 deals with report on the annual general meeting, which is simple and straightforward. In which form? MGD 15. Okay, MGD 14 was what? See, now let's quickly remember the form numbers. Let's quickly recall. MGT 12 and 13 was with respect to the scrutinizer. Okay, one is the polling paper as per MGT 12, and MGT 13 was your report of the scrutinizer. MGT 14 was the resolution that needs to be filed with the ROC. Then MGT 15 is the report of the general meeting, which is in MGT 15, which needs to be filed within 30 days of the conclusion of annual general meeting. Okay. Then who signs the report? The chairman of the meeting, or in case of his inability, then two directors, one who should be a managing director. Okay. And the company secretary of the company. Clear? That's it. And duties of the CS. Think this you can go through it. Okay, so this was your general meetings. Okay, I hope these two videos regarding general meetings was very much helpful. Let me know which other chapter that I should be recording the revision classes for, and we will be doing that. And as always, the notes that I am using here will be in the description down below. You can directly download them and use it for your studies. And all the best for you. I'll see you guys in the next video.